Why, hello there, and welcome to this video. Today, I have 4 stories to bring you. 3 of them are positive, and 1 of them is negative, but overall, it's going to be a positive show today. It feels nice to bring you guys some hopeful news and some positive news because I don't know if you pay attention to what's going on at a macro scale right now with our government, but it feels like everything is crumbling around us. The billionaire oligarchs are robbing and pillaging our government for every single penny so they can enrich themselves and make our lives miserable. And I know that I don't talk about all of that macro political stuff that's going on right now, and that's because I am picking my battles and I'm choosing to focus on, the stories that are important to my community. There are tons of other people talking about everything that's going on, and I highly recommend you check them out. But, I'm here to talk about this stuff. So that's what I'm going to be doing. Okay, so we're going to jump straight into the stories today and get talking about those. I just wanted to say briefly before we get going, Erin in the Morning, I'm using her as a source for all of today's stories. She is amazing. She covers all of this stuff at an incredible level of depth. And if you are looking for someone to keep you informed, I highly recommend her. She posts on a ton of different social media platforms. She has her own website here, Erin in the Morning, where she posts articles that go into detail about all of this stuff that's happening. She is like fighting the good fight. She's an incredible person. I really highly recommend that you subscribe to her website so that you can stay up to date with all of this stuff. But all right, this is the first story right here. So judge blocks Texas A&M drag ban. Trump executive orders cannot override First Amendment. The Texas A&M board banned an LGBTQ plus group from holding a drag event on campus. A federal judge has ruled they must be allowed to proceed with the event. Judge Lee H. Rosenthal, a federal judge appointed by President George H.W. Bush, has blocked Texas A&M University from banning drag events on campus. The ruling comes in response to a lawsuit filed by the student-led LGBTQ plus group Queer Empowerment Council, which had hosted the annual Draggyland event for 5 years without incident. In her decision, Rosenthal found that drag is a protected form of artistic expression under the First Amendment, and that Trump's executive order targeting so-called gender ideology cannot supersede students' free speech rights. Performances by men dressed as women are nothing new. Men have been dressing as women in theater and film for centuries. It is well established among scholars of Shakespeare's literary works that when his plays were written and performed, female characters were played by young men dressed in women's attire. See Royal Shakespeare Company, Women on Stage, the court wrote, before concluding that the drag show qualified as protected First Amendment conduct. The theatrical performance and explicit discussion of the intended message are both protected under the First Amendment. The Texas A&M Board of Regents, in a letter denying the student organization permission to host its drag event, claimed that drag is inconsistent with the university's system's values, but insisted that the decision was unrelated to the show's speech or viewpoint. The board finds that it is inconsistent with the system's mission and core values of its universities, including the value of respect for others, to allow special event venues of the universities to be used for drag shows that involve biological males dressing in women's clothing, wearing exaggerated female makeup and or exaggerated prosthetics meant to parody the female body type, the letter stated. It went on to claim such performances are likely to create or contribute to a hostile environment for women, contrary to system anti-discrimination policy in Title IX, alleging that drag shows often involve unwelcome and objectively offensive conduct based on sex, particularly when they involve the mockery or objectification of women. The judge was not persuaded. In a separate line of argument, the state stated that the university had to ban the show because it promotes gender ideology, which it claimed was prohibited under a recent Trump executive order. Given that both the system and the universities receive significant federal funding, the use of facilities at the universities for drag show events may be considered promotion of gender ideology in violation of the executive order and the governor's directive, the state wrote. The judge pointed out the clear contradiction in the state's argument, on one hand claiming the drag show ban had nothing to do with speech or expression, and on the other, arguing that the show's expressive content warranted the ban. The board's contention that drag shows and Draggyland are not expressive conduct, just Draggyland really is just getting me there. The board's contention that drag shows and Draggyland are not expressive conduct directly contradicts the board's simultaneous assertion that drag performances promote an ideology, the judge wrote. The executive order cannot override First Amendment protection, said the judge. This order is one of several across the United States that have blocked drag bans, contributing to a growing body of case law affirming that drag is a form of artistic expression protected by the Constitution. It is also significant that the ruling came from a judge appointed by George H.W. Bush at a time when gender and sexuality issues have become increasingly polarized in the courts A Republican-nominated judge citing against a drag ban marks a notable moment. Today is a resounding victory for the First Amendment at public universities in Texas, said Adam Steinbaugh, an attorney with the Foundation for Individual Rights and Expression, who argued last week at the district court. The court reaffirmed that state university officials cannot block student expression they claim is offensive. State officials should stop trying to score political points at the expense of students' First Amendment rights. Tickets to the show became immediately available following the ruling, and it now appears to set to proceed on its originally scheduled date of March 27th, which is like tomorrow for me, which is pretty cool. So this is a really good story. It's nice to see that this was a federal judge appointed by George H.W. Bush giving this ruling, because it goes to show that, like, even if they're appointed by a Republican, these judges tend to be more principled than like the average Republican politician. Like, Republican politicians will scream about free speech and scream about the First Amendment and scream about censorship, but then they'll do this. They'll literally censor people and literally ban people and like stomp on free speech rights. And so the judges are, you know, a little more principled in that sense. They're saying like, hey, you know, it doesn't matter whether this is agreeable or not. This is free speech. This is the First Amendment. This is about the right to free expression. So, you know, but I'm not going to linger too long on that story. Let's go ahead and jump into one more positive one. Soaked in animus, federal judge strikes down Trump's trans military ban. I actually mentioned this, I think, in my last video, that this ruling was going to come down soon, and here it is. The cruel irony is that thousands of transgender service members have sacrificed, some risking their lives, to ensure for others the very equal protection rights the military ban seeks to deny them. I think that's a powerful quote. I just want to like focus on that for a second. Like, that is a really powerful quote right there. Essentially, it's just saying that like these service members are serving our country. They're giving like a lot of themselves. A federal judge has blocked President Donald Trump's anti-trans military ban, including Executive Order 14183, prioritizing military excellence and readiness, as well as a similar policy issued by Defense Secretary Pete Hegseth. So it's not just the executive order, it's also a policy issued by Pete Hegseth. The cruel irony is that thousands of transgender service members have sacrificed, some risking their lives, to ensure for others the very equal protection rights the military ban seeks to deny them, wrote Judge Anna Reyes, a Biden appointee, in her opinion published today. And the self-evident truth that all people are created equal, all means all, nothing more, and certainly nothing less. Like that's powerful right there. That's a powerful statement. It's like awesome to see judges like stand on principles like that. The court affirmed the president's ability to discern who can serve the military, but emphasized the high standards needed to do so. Leaders have used concern for military readiness to deny marginalized persons the privilege of serving, she wrote. First minorities, then women in combat, then gays. Today, trans people are the target. Trump's executive order from January declared that being trans conflicts with a soldier's commitment to an honorable, truthful, and disciplined lifestyle, and that it is not consistent with the humility and selflessness required of a service member. The order was accompanied by Hegseth's anti-trans memo to the Pentagon on February 7th. To categorically ban trans people from the military, the government would have to show that trans inclusion has resulted in tangible material harm. The court ruled that this is not the case. Even more, Reyes said that neither Trump's executive order nor Hegseth's directive seem to have received input from military rank and file, which is actually interesting just to say really quick. I've had people pop into my live streams and say like, hey, I serve with trans military members, and they are incredible service members. They put their heart and soul into it, and they're really dedicated, and they're super honorable. So like hearing from the small subsection of military folk that I've heard from, they have absolutely no issue serving with trans folk. Neither document contains any analysis nor cites any data, Reyes cites. They pronounce that transgender persons are not honorable, truthful, or disciplined, but defense counsel concedes that these assertions are pure conjecture. The plaintiffs, Reyes continues, have cumulatively provided over 130 years of military service. They have served in roles ranging from senior military science instructor to artillery platoon commander to intelligence analyst to satellite operator to operations research analyst to naval flight officer to weapons officer, she writes. They have deployed around the globe. One is presently deployed to an active combat zone. They have earned more than 80 commendations. The ban was not only discriminatory, Reyes says, but also unscientific. Who considered the information is anyone's guess. Trump officials do not know. Maybe no one, because one study is 8 years old and the other two support the plaintiff's position of opposing the trans military ban. She characterizes the ban as soaked in animus and dripping with pretext. Its language is unabashedly demeaning. Its policy stigmatizes transgender persons as inherently unfit, and its conclusions bear no relation to fact, Reyes writes. Thus, even if the court analyzed the military ban under rational basis review, it would fail. Trans people have been formally allowed to serve openly in the military since at least 2021. Our military has not fallen into an existential crisis, Reyes points out, nor have our lethal and effective soldiers come unglued when asked to use preferred pronouns, which the Hegseth policy also bans. In fact, evidence submitted to the court seems to suggest the contrary. Recruiting, unit cohesion, and military readiness have since improved. The Trump administration will have until the morning of March 21st to file an emergency stay to appeal Reyes' ruling. If this happens, the question could eventually rise to the Supreme Court. So this judge was kind of giga-based, like honestly super amazing. I love like this quote that I read at the top, that one about the cruel irony of it. I feel like that's really poignant, and I really like that quote. But really, I don't have anything else to say about that. I'm kind of nervous to see if something like this goes up to the Supreme Court, but this kind of stuff has happened before. I mean, this happened during his first term, the military ban, and it was countered by the courts. So I don't know. We'll see what happens. So far, the courts are sticking up for us. So I was trying to figure out whether to end with the negative story or to end with a positive story. I think ending with a negative story would just kind of like end the video on a bad vibe. And so I'm going to go ahead and do the negative story, and then we'll go ahead and do the last positive story. Ninth Circuit upholds bathroom ban, says trans students violate cis people's privacy. The ruling, the first of its kind, asserts that the rights of cisgender people to not have a transgender person in the same bathroom are more important than the equal protection of trans students. In a stunning decision, the Ninth Circuit Court of Appeals has ruled that Idaho can ban transgender students from using bathrooms that align with their gender identity. The ruling prioritizes cisgender students' privacy concerns over the harm faced by transgender students, effectively stripping them of Title IX protections in school facilities. It also contradicts recent precedent from both the Ninth Circuit and other federal courts that have affirmed equal protection rights for transgender people. Even under heightened scrutiny, the court determined that transgender students could legally be excluded from bathrooms corresponding to their gender identity due to unspecified harm that they may be hypothesized to cause cisgender students. In multiple instances, the decision also treats transgender students as their assigned sex at birth, setting a dangerous legal precedent with implications far beyond Idaho. The court ruled that a privacy interest in excluding transgender students from bathrooms outweighs their equal protection rights. It stated that not exposing students to the unclothed bodies of students of the opposite sex and protecting students from having to expose their unclothed bodies to students of the opposite sex justifies barring transgender students from locker rooms, changing rooms, and bathroom. It also stated that a person's sex is typically identified at birth and treats biological sex as sex assigned at birth, without justification. In doing so, the ruling explicitly categorizes transgender youth as the opposite sex in legal terms, setting a precedent that could further erode their protections under federal law. Though the ruling acknowledges that the transgender plaintiff, Rebecca Rowe, alleged that excluding her from those facilities would jeopardize her social transition, imperil her mental and physical health, and out her to her peers as transgender when she entered a new school in 7th grade, the ruling does not find that harm compelling. That is because the ruling determines that despite the harm done to Rowe, the state has a compelling interest to protect cisgender students from Rowe and intimate spaces. The ruling acknowledges that Idaho's bathroom ban discriminates on the basis of sex and transgender status, triggering heightened scrutiny as required by Ninth Circuit precedent. Yet, despite this recognition, the court still ruled against the transgender plaintiffs. It determined that the state's interest in preventing schools from requiring students to share restrooms and changing facilities with members of the opposite biological sex advances privacy and safety objectives and prevents potential embarrassment, shame, and psychological injury to cisgender students. This, the court concluded, was sufficient justification to overrule the documented harms experienced by transgender students. The ruling further denied equal protection claims, asserting that excluding all students, including transgender students who have not undergone gender reassignment surgery, from locker rooms and shower rooms designated for students of the opposite biological sex is substantially related to the same privacy interests. Before we jump into the next paragraph, I just want to make it very clear. What they're saying here is that being sexually abused or discriminated against is fine for the transgender youth because they might accidentally cause embarrassment or shame or psychological injury. And this is like hypothetical shame, hypothetical embarrassment to cisgender students. So like essentially saying that the rights of the transgender student are not as important as the rights of the cisgender student to some hypothetical, like this is like the argumentation here is ludicrous. To justify this decision, the panel had to address the fact that the state failed to produce any evidence of harm caused by transgender students using bathrooms or changing rooms. Rather than confront this gap, the court sidestepped the issue by creating what effectively amounts to a transgender injury exception. It ruled that common experience is enough to assume harm to cisgender students, stating, Saga overlooks that this is an unusual situation in which the state's privacy justification is easily corroborated by common experience, that some students in a state of partial undress may experience embarrassment, shame, and psychological injury in the presence of students of a different sex is neither novel or implausible. In doing so, the court required no actual evidence of harm to justify the ban under heightened scrutiny. So you heard that right. They are basically saying that hypothetical harm, common sense dictates that the actual harms, the real documented known harms to transgender students are less important than these potential hypothetical harms that we think might happen because of common sense with literally no evidence to back it up. Crazy. The court sidestepped strong precedent affirming transgender people's equal protection rights, including a case which states that the mere presence of a transgender person does not violate cisgender students' privacy in shared spaces. To do so, it reframed the issue, claiming that the mere presence of a transgender student in bathrooms was not at issue in the case. Instead, the ruling asserts that transgender people are not being discriminated against for their presence, but rather are simply being told they must be treated as their assigned sex at birth, a distinction that functionally erases transgender identity and legal protection. The ruling also denies transgender people protection under Title IX, explicitly allowing Idaho to define transgender students by their birth sex within the law's framework. This could have far-reaching consequences, as courts have ruled that Title IX protects transgender students from discrimination. If this interpretation gains traction, it could be instead used to mandate discrimination by requiring students to treat transgender students as their assigned sex at birth. The ruling states, but from the time of the enactment of Title IX and its implementing regulations, the scheme has authorized schools to maintain sex-segregated facilities, and contemporary dictionary definitions commonly define sex in terms that refer to a student's sex assigned at birth. Lastly, the court rejected transgender students' claims under the right to informational privacy. While it acknowledged that such a right might exist, it ruled that Idaho law does not compel transgender students to disclose their gender identity because anyone may use a single-use bathroom. This reasoning ignores the reality that transgender students who are disciplined for using a restroom that matches their gender identity will, by default, be forcibly outed to their peers. This ruling sets a devastating precedent for transgender rights, issued by a majority Democratic-appointed panel in the Ninth Circuit, which is super disappointing. It marks the first significant decision in which Democratic-appointed judges have ruled against transgender protection. By prioritizing cisgender discomfort over the tangible harm faced by transgender people, the court has effectively sanctioned a legal framework in which transgender individuals can be forced to live as their assigned sex at birth. Even more troubling, this decision comes at a critical moment, just ahead of a looming Supreme Court case that will determine whether transgender people have equal protection under the law at all. That such a ruling emerged from the historically progressive Ninth Circuit signals that courts may be increasingly willing to uphold laws restricting transgender people's rights, potentially paving the way for a wave of anti-trans legislation to be deemed constitutional in the months ahead. So this story was really disappointing to read and to see. It's really disappointing, first of all, that it was a Democratic majority panel, like a usually a rather progressive panel that went ahead and issued this decision. It just goes to show that just because someone is a Democratic appointed person, or just because someone is generally progressive, does not mean that they are going to be an ally, or does not mean that we should rely on them or that we should trust them to do what's right for us. We got to fight for our rights, and it's just sad to see this. Now, I do think that this is a dangerous precedent. I do think that this is disheartening, and I do think that this is frustrating, but it does say something to me that this is the first of its kind, and that this is like the first time this kind of argumentation has been used. Like, maybe we will see this kind of decision reiterated in other places and held up in other places as well, but I kind of don't know about that. Like, I'm not quite sure whether that will happen or not. I know that, the tone of the article is pretty dark, and essentially says that this is, paving the way for some really horrible stuff. And it could be paving the way for some really horrible stuff. But I mean, as we see in these other articles that we are reading today, a lot of judges are ruling positively in our favor for our rights and standing up for us. So hopefully this is just like a decision that is one of a kind and stays that way. That would be the hope, essentially. Okay, so this is the last article, and I honestly saved the best for last. If you don't know, I live in Ohio, and I saw this ban go into effect. It was a deeply disheartening time. Like, they tried to ban adult healthcare as well, like gender affirming care for adults. They also tried to target that. They essentially tried to regulate it so heavily that it would have banned healthcare for like 80% of Ohio residents that are trans. And it was just a very dark time. And even though we were able to save adult care, we were not able to prevent them from banning gender affirming care for minors in Ohio. But we have this article. Ohio Appeals Court rules that trans care is healthcare, strikes down ban for trans youth. The ruling was in part based on a 2011 amendment in the state guaranteeing healthcare freedom, originally meant to challenge Obamacare. In a landmark decision on Tuesday, a 3-judge panel for the Ohio 10th District Court of Appeals struck down the state's ban on gender-affirming care for transgender youth. The ruling rested on 2 key findings. First, that gender-affirming care constitutes legitimate medical treatment, and second, that parents have the constitutional right to make healthcare decisions for their children. True. Republicans always say that they care about parental rights, and then when it comes to parents getting care for their children who are trans, all of a sudden that principle is gone. Notably, with a touch of irony, the court's decision was made possible by Ohio's Healthcare Freedom Amendment, a Republican-backed constitutional provision originally designed to undermine the Affordable Care Act. Now, the same amendment has been used to dismantle a key pillar of the state's anti-trans legislation. The medical evidence and clinical experience presented in this case demonstrate that, when provided in appropriate circumstances, gender-affirming care can meaningfully improve the health and well-being of transgender adolescents with gender dysphoria by lowering rates of depression and severity of other mental health issues, as well as increasing patients' quality of life, reads the ruling, affirming many studies showing the importance of gender-affirming care on the well-being of transgender youth. This finding was significant. In 2011, a state constitutional amendment was passed by Republicans to prevent the implementation of the Affordable Care Act. The amendment reads as follows. B. No federal, state, or local law or rule shall prohibit the purchase or sale of health care or health insurance. C. No federal, state, or local law or rule shall impose a penalty or fine for the sale or purchase of healthcare or health insurance. As a result, Ohioans now have broader constitutional protections around healthcare access, protections that, in this case, worked against Republican lawmakers' attempts to restrict gender-affirming care. In defending the ban, the state argued that gender-affirming care does not qualify as healthcare, relying on testimony from anti-trans medical quote-unquote experts, and asserting that it was up to the legislature, not the courts, to determine what constitutes medical treatment. The judge rejected both arguments outright, affirming that gender-affirming care falls squarely within the legal definition of healthcare. The court thoroughly dismantled the credibility of the state's witnesses, going so far as to eviscerate them in judicial footnotes. Of Dr. James Cantor, the ruling notes that he is not a physician, has never practiced as a licensed clinical psychologist in the United States, is not licensed to treat patients under the age of 16, and has never provided treatments to patients under the age of 16. Dr. Paul Hrutz fared no better, with the court pointing out that he has never diagnosed or treated a patient with gender dysphoria. The ruling also highlighted his history of anti-trans advocacy, citing his testimony in a transgender bathroom ban case where he stated, conditioning children into believing that a lifetime of impersonating someone of the opposite sex, achievable only through chemical and surgical intervention, is a form of child abuse. Even the state's sole witness with marginal qualification, Dr. Stephen Levine, ultimately undercut its case. The court noted that while Dr. Levine has experience in the field, he testified that he does not support a categorical ban on gender affirming care and provided no evidence that such care is substandard in Ohio. In other words, the state's own expert failed to justify the ban. See the court's critical appraisal of the witnesses, often cited in many anti-trans cases. And then, like, you can read this if you want. We read some of this stuff up above, essentially like the court just going hard against these anti-trans, quote unquote, experts, talking about how they're full of crap. The court dismissed the state's anti-trans witnesses outright, instead finding the testimony of 22 leading medical organizations and numerous appellate witnesses, many with decades of experience in transgender healthcare, far more credible, citing extensive studies on the positive impacts of gender-affirming care in reducing suicidality and depression. The court made clear that the overwhelming weight of medical evidence supports access to this care. The court also rejected the state's claim that the legislature has the authority to unilaterally define what qualifies as healthcare. The General Assembly cannot simply declare any type of healthcare to be wrongdoing and swallow up the right enshrined in the Ohio Constitution by direct vote of Ohio citizens, the ruling stated. Instead, the court asserted that the state must present a compelling case as to why a widely accepted standard of care should be excluded from the definition of healthcare. Not only did the state fail to make that case, but it also could not provide a single alternative standard of care with evidence of positive outcomes for transgender youth. So that's pretty impressive. Like, honestly, I love the way that they stated this. It could not provide a single alternative standard of care with evidence of positive outcomes for transgender youth. Because a lot of these anti-trans people, a lot of these anti-trans advocacy groups, they try to advocate for things like conversion therapy, which we know does not work and we know has really bad outcomes. And so, like, even if they tried to provide like alternative standards of care, they would provide standards of care that are actually just negative, that will just harm people. Though this would have been in and of itself enough to overturn the law, the court proceeded to also rule that the anti-trans ban was a violation of the parental right to direct a child's health care. Based on the foregoing, we conclude that parents have a fundamental right to seek medical care for their children, which naturally includes the right of parents to, in conjunction with their minor child's consent and their medical provider's recommendation, make a judgment that such medical care is necessary. Frida Levinson, legal director at the ACLU of Ohio, celebrated the decision. Today, we celebrate this win not only for our brave plaintiffs, but also for all LGBTQ plus Ohioans and their families. This win restores the right of trans youth in Ohio to choose vitally important health care with the support of their families and physicians. We are gratified by the court's decision, which soundly rejects this interference of politicians with Ohioans' bodily autonomy. Although this litigation will likely not end here, we remain fervently committed to preventing this egregious bill from ever again taking effect. The path towards protecting the rights and civil liberties of trans Ohioans goes on, and we will continue to hold the torch. The ruling will likely be appealed in coming days to the Ohio Supreme Court. So that last sentence is pretty important. Like, it probably will get appealed and it'll probably go up to the Ohio Supreme Court. But I feel like the ruling given here provides such a framework of the entire thing that is so crystal clear that the Ohio Supreme Court would have to be absolutely bonkers to like rule against this and like side with the anti-trans advocacy groups. Seriously, the case made for gender affirming care is so resoundingly solid. Like, it's backed by science, it's backed by testimony, and it's also like the principled thing to do. Like they said, you know, parental rights are important. The government has almost no business stepping in the way of what medical professionals and parents think is necessary for their children. Like, it's just not, it doesn't make any sense. You know, a lot of these Republicans are so principled about parental rights and freedom, but then all of a sudden when it comes to marginalized groups like LGBTQ plus people, they just decide like, oh, well, actually, freedom ends at a certain point. Like, not everyone gets the freedom. Like, we get the freedom to be bigoted and to be terrible, but you don't have the freedom to make your own medical decisions. You don't have the freedom to do what you want with your body and with your life and with, you know, parental consent and with medical doctor recommendations. So we shall see what happens, but I'm feeling pretty confident after reading how the court justified everything and talked about everything that things are going better in Ohio than I expected. But yeah, those are all of the stories that I wanted to bring you today. I feel like overall, some pretty positive stuff. It's nice to see that consistently with the exception of like that Idaho thing, the Ninth Circuit Court, rulings have been favorable towards us. The battle for our rights has really ramped up, especially with the second Trump administration. And it seems like the courts are kind of holding ground for us. Like they really are checking out the evidence and in good faith approaching testimony. And it seems like with the exception of maybe that Ninth Circuit Court making that decision in Idaho, we have like favorable rulings all over the place. So I know that it's tiring. I know that things are exhausting. I know that things are depressing and it's gloomy out there, and it's hard to feel like there's any hope for the future. But I feel like all of this focus from the politicians on our rights has led to this crazy battle that's going on in our society, and we're making ground. I feel like it has created, I don't want to say like a backstop. I don't want to say that it's impossible for things to backslide super far, but it genuinely feels like we have made so much progress that we are not going to see our rights just whole cloth stripped from us. Like we're not going to just be reduced to second class citizens in every sense of the word. Hold on to hope and keep fighting, because we will get through this together. We will find a way forward, and we are not going anywhere. So as you may be aware, I have a Discord, and that Discord is accessible through a link tree in the description of my videos. So you just open the description of my video. There's a link tree right there. You click it, it opens up, and you can see my Discord. You can go ahead and jump right in there. There's a short verification process, but we have a growing community of people in there that are seeking other people that they can vibe with and find support and communal stuff. It's honestly a great place, and we would love to have you there. So just feel free to join. As you may be aware, I have a Patreon. So we're going to have Patreon members popping up on screen right now. You can see them flashing up on the screen. I appreciate my Patreon members so much. I've seen such a momentous amount of support lately on the Patreon that I'm actually going to be able to make some improvements to my content. Like, this is really exciting. I am working on it, but I should be able to have an editor soon, if not already. And that takes a tremendous load off of my shoulders. Like, it's 1 a.m. right now, and if I had to edit this video by myself, usually I would be up until like 5 or 6 in the morning getting it prepped to be launched tomorrow. But if I have an editor, I can record this video and then like relax a little bit, and I won't have to be up till 6 in the morning working on it. Maybe I can make more content. If I just have an hour to record a video at night, then that's enough time for me to get a video done. So of course, I don't want to make promises before I'm able to commit to those promises, but I'm thinking here soon I will be able to move forward with 2 videos a week and a stream, which would be super wonderful. I'm also looking at potentially releasing short content, like shorts. I'm thinking maybe I can clip up short segments of my streams that are funny or interesting, or just like engagement with chat or whatever. And those things can make fantastic short form content. So I think that would help bring more eyes to my channel. I'm really, really going hard on this. I want to try to grow my platform. I want to try to be here and fight for everybody and do what I can for our community. So I won't linger much longer. I just want to go ahead and shout out my super supporters. These are my top tier supporters, and I got to thank them so very much, because their support is really, really helpful for helping me build up a funding mechanism for my channel to improve my content and better things. Of course, all of my paid members are important. Of course, all of them matter, but my top tier supporters go above and beyond. And for that, I'm super grateful. So we actually have a new super supporter to shout out. Kate, thank you so very much for becoming a super supporter. It warms my heart. Like, seeing a new super supporter is just like a very special thing. It's like, oh my gosh, like it's one of those things where you set up the top tier and it's like, no one's gonna get the top tier. Like, I'm gonna put it up, but no one's gonna get it, but you actually got it. So thank you very much. I also want to shout out the rest of my super supporters: Cal Fiore, Jasmine Wilson, Maddie, Trisha Pizafrad, Katie Bug, Sarah J. Buck, Nikki Notzel, Sarah, and Sam Howard. Thank you so very much yet again. I appreciate you all a bunch. You can check out my Patreon in my link tree as well if you want to get involved and help fund the channel and improve my content moving forward. I would super appreciate it. It would mean a lot. Go ahead and hit the like button, subscribe if you haven't subscribed already, and leave a comment down below. Let me know what your favorite story was and why. Like, which story did you think was the best one, or the most hopeful, or the most positive? Which one had the most impact on you and why? But with that being said, I think that's all. I think that's the whole video. I think that's the whole thing. So there's only one thing left for me to do, and that's for me to make a tiny little request of you. It's just like the smallest thing, but it's really important, but it's small, but it's important. And that thing is for you to drink some water.